Our topic is bias and how we can apply psychological principles to meet the inevitable jury bias that comes into the courtroom with each new jury panel. Our first principle is that jurors see the world not as it is, but as they are. The same thing applies to your lawsuit. Jurors see your case not as it is, but as they are. It's very important that we see the case through the eyes of jurors, because we are the most biased people in the world about our lawsuits. We have tunnel vision. We are so totally immersed in our case that we can only see it from our side, even though we try diligently to see it from both sides. And, well, what would I do were I the defense lawyer in this case? What would I do were I the judge in this case? We still deal with our own biases. So the way we see things and the manner in which jurors see it is through the use of focus groups. We did 4 focus groups earlier this week on 4 different cases. Those are baseline focus groups. A baseline focus group is one where you test how a jury feels about your case without any persuasion, without trying to move them in any direction at all, but rather by simply getting a feel for, given plain old vanilla facts, both from the plaintiff side and defense side, how does the jury feel about your case? Then you take the data that you get from the baseline focus group and you try to identify what biases are there that apply to my particular case. And to understand that, we have to understand the role that bias plays. The first role that bias plays in a lawsuit is as a filter for the evidence. If someone comes in and they have a predisposition, they will filter their receipt and processing of evidence through that predisposition or through that bias. But a more important role, that I think the most important role that bias plays, is to fill the evidentiary gaps. And we frequently leave gaps in our evidence. For example, if you find yourself saying, oh, everyone believes that, or nobody would take that position, when you start finding yourself using universal terms, that's a cue that you're probably wrong, because everybody doesn't believe everything and nobody rejects everything. There are viewpoints from jurors that will be across the board, everything from Gen Y to the senior citizens and all the spectrum in between. We have to find out what the evidentiary gaps are. There is no better way to find the gaps in your evidence than through the use of focus groups. And what we've done this week is we've done a baseline focus group where we presented basic information to focus group members on 4 separate cases, and we listened to how they talk about the case, and we listened to what questions they had. We listened to what they thought was important in the case, what they thought was not important, the things that were important to them, why were they important, how much controversy was there on various points, how much unanimity was there on various points, so we could find out where the areas of dispute were, we could find out where the evidentiary gaps are. The role of bias, and by bias I mean just predilections, predispositions to lean one way or the other. What we find is that when people come in with those predispositions, if they are discussing your case as a jury, and one of 2 things has happened: either they have rejected the evidence on both sides, or they don't recall that there was any evidence presented, that leaves a gap in your evidence. And what happens when you leave a gap in the evidence? You leave the perfect opportunity for a juror with an agenda, such as a tort reformer, for example, to come in, and that's where they impose their bias upon the other people. And even people who are not in there with an agenda, when there's a gap in the evidence, they start telling their life experiences. Well, I had a cousin who was like this, and they didn't have any problem with it, that sort of thing. So you want to be sure that you leave the minimum number, ideally no gaps in your evidence, that would open the door and invite biases. Two things you have to understand about bias. One, the true biases are based on value beliefs, and they're based on the meaning that jurors have placed on their life experiences. And since they're based on value beliefs, you're not going to change biases on voir dire examination. You're not going to change it on opening statements. You're not going to change it in the evidence. You're not going to change it in summation. So how do you overcome jury bias? You have to get them to set aside the biases that they have just for the purposes of your lawsuit. And there are a number of psychological principles that we use in order to accomplish this. We'll talk about the important factor about the role of bias. In the absence of compelling new data, bias completes the evidentiary model. In other words, people come in with their own leanings, their own predilections, their own biases about the case. Unless they hear something compelling that changes that moves them off of their bias, bias will play an important part in their evidentiary model. So we're going to talk about the various ways that the lawyer can control and use the predilections or biases or leanings of the jurors and bring them around to your viewpoint. And there are definite psychological principles that apply. And these principles are very much in our control to some extent. And the ones that are not in our control, we'll talk about how to deal with them.